Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I'm right here each and every Sunday from 8 to 9 a.m. on this station to bring you, the Pennsylvania landowner and oil and gas right owner, the information that you need regarding natural gas development. At the Clark Law Firm, my focus is on land owner, oil and gas right owner representation. I have not, I do not, and I will not represent gas or pipeline companies. I've dedicated myself and will continue to represent our area landowners, Pennsylvania landowners, and oil and gas right owners, because we need people fighting for you, not just the companies. And I represent people for oil and gas lease reviews, consultations, negotiations, pipeline agreements, multi-unit well consent reviews and consultations, unitization issues, well pads, releases. I talked about releases. Boy, if you're going to sign a release, get it to an attorney and have it reviewed before you sign it, because you're probably, well, I'll put it this way, you may be giving up significantly more rights than you realize. So you need to have these things reviewed. Also, doing more with estate planning, buying and selling gas rights. If you're selling your gas rights or if you're buying gas rights, but normally I do a lot of representation, more representation with people who are interested in selling their oil and gas rights. I'm telling you, before you go down that path, I would recommend you give us a call. You can always call the office, 570-307-0702. Find out about reviews and consultations and maybe have a discussion with me before you make any decisions. And again, this same thing applies with any document. Anytime you're given a contract, remember that despite there being a local landman or a landman sitting at your table or coming to your house, that contract, look at the name in that contract. That contract is coming typically from a major oil and gas producer or pipeline transportation company. And that's not, again, I say this often, that's not cutting a deal to sell your hay in the field like my dad and my grandfather do or have done. No, these are major contracts for industrial operations on your property, drafted and that have evolved over decades and decades. And when I say that, what I mean is the companies will draft these contracts, see when there's a problem that they don't like how something maybe benefited the landowner and not the company, and they tweak or change the contract to make it even more company friendly. And that's what you need to understand, and we need to talk about that, you or whether me or someone else. But you need to understand what this contract is. And I'm going to talk today. And I'll tell you honestly, I'm really excited about this show because I'm going to talk about this multi-unit well consents. I'm going to talk about people who are receiving new leases, top leases or new leases, when they already have an existing lease. So this is one of these shows where people in Susquehanna County and the edge and the eastern side of Bradford County mostly are receiving requests from Cabot Oil and Gas for consents to allow the company to drill what are called multi-unit wells. Can get very complicated and very confusing. So we're going to talk about that some and the need and why you need to either talk to me or talk to somebody. Again, if you're not talking to me, you need to be talking to somebody working for you to make sure you understand these things. Or what you need to understand, because simply signing can have a major detrimental effect on you in the future, depending on your specific situation. Not your neighbor's situation, but your situation. Then we turn and we look to the area of Tioga County, and we see that there's been a rash of Shell Sweppy LP offering landowners new leases when they already have an active and valid lease. And you need to be asking yourself why. I've talked a lot about it. I will continue to talk about it because, in my opinion, well, I have a very strong opinion on this, that the new lease that you're being offered is not going to end up to be something that's going to be to your benefit in the long run. Now, remember, I said these leases and these documents evolve over time. Companies change them when they find ways that they think they should change it because maybe there was a bad court case and now they want to change the language so that court case won't apply to this document or this lease or this pipeline agreement or whatever it may be. Maybe that's a reason. Maybe they find that another company is paying royalties in a different fashion and that company has figured out a way to pay the landowner less royalties and keep more of the money. And so they say, hey, let's change the language in our contract in order for us to, as a company, take more of the royalty payments for us and not pay them to the landowner. Think about that. And my opinion, I strongly believe that is what's occurring in Tioga County. And when I do these reviews and consultations, we talk about these issues. We talk about the specific situation for that particular landowner, not for the friend of that landowner, not for the neighbor, but no, we look at your situation. We discuss it. We talk about the pros and cons, the benefits and the negatives of a new lease and what the language is, and we go over all of that so you have the tools and information. Same thing with the multi-unit well consent reviews and consultations, that you then have the tools and information to decide, is this what you want to do? Does this make sense? Is it in your best interest? What am I doing when I do this? Am I going to harm myself? Am I increasing my chances of royalties? Am I decreasing my chances of royalties? Am I giving up on royalties that I might otherwise have obtained had I not signed? Or by signing, will I avail myself of more royalties in the future? So is it in my best interest? So you got to look at all of those situations. And boy, I can't say it enough that not every situation is different. And literally, you could have a 10-acre parcel and your neighbor has a 10-acre parcel and it could be right beside each other and your evaluation could be extremely different than your neighbor's. That is very important to understand. You can't just rely, oh, my neighbor did this, my neighbor did this. And that just reminded me, I'm so glad that I didn't forget this. Well, I forgot it and then I got reminded. I had somebody come in this past week who handed me a document. And it happened to be a multi-unit well consent form. But handed me a document. Now, it doesn't have to just be the multi-unit well document. It could be all kinds of different documents because I've seen this before. So they hand me a document and they say, well, the company people came out, they're talking to me. And they said, this is going to be so great for me and all the different reasons why. It's so great, so great, so great for the environment. Great, great, great. Here's my pen. Here's a pen. Here's a pen. Here, I'm a notary, sign. Oh, by the way, landowner, this form isn't the same that we've mailed out to everybody. It's not the same form because we've added something here. And here, I'll show you. And this is what an attorney who represented a landowner requested. And we had this document changed. And now we'll offer that same thing to you. So the idea being you're getting free improvement of your document. And you're getting the assurance that, wow, this must be good because an attorney worked on this for another landowner. So I can piggyback off of this. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you tune in every Sunday, 8 to 9 a.m., right here on this station. And give us a call, learn about what we do, learn about these reviews and consultations, and do it before you sign. Before you sign, 570-570-5262. 570-307-0702. If you have the multi-unit well consent, give us a call, learn about the review and consultation, see if we can help you, and then decide if you want to go forward. But give us a call. Learn from somebody who's working for you. 570-307-0702. Okay, I want to go back now. I'll just refresh here. So what happens is landowner comes to my office, shows me a multi-unit well consent form. Again, let's not get stuck on the form for this illustration, but says, hey, here's a form that another landowner paid an attorney to work on, and it's not the typical form. We've made it better for you, the landowner, because this was negotiated or worked on by another attorney representing another landowner. Multiple problems. Hopefully, regular listeners know that, number one, what is right for a neighbor or any other landowner does not mean it's right for you. First and foremost, the next door neighbor can have an entirely different evaluation process than you should and do when you know what you're looking at and you know how to evaluate these offers and different documents are being presented to you. That's number one. That's the starting point. But boy, it goes way deeper. Number two, who in the world knows what this lawyer did, what they knew? Did they understand these issues? Did they fight aggressively? What kind of leverage did their client have? Did they just mail it in? What kind of teeth are involved in these changes? All of those things come into play. Was it a lawyer who does only divorce cases and just dabbled into this oil and gas for their relative? I don't know. Or was it somebody that does oil and gas and was hired, and did they not do a good job in this case? Did their client have the same leverage that you do? Maybe they had more, maybe they had less. You can't. I tell you, it kills me because here's what you can do as a company. You go out and you ask a bunch of lawyers or a bunch of landowners to sign documents, to sign anything, to sign a document. Then some of these landowners, say you got 100 people, they're going to hire, some of them are going to be, in my opinion, smart and hire a lawyer to work for them, and the right lawyer for them, whether that's me or someone else, hire somebody who's right for you. So they hire lawyers, and then lawyers try to negotiate and work on these documents. So what do you do as a company? Well, one of the lawyers sends you something back. You say, oh, this is no big deal at all. Okay, we'll approve it. The other one sends some things back, and you say, well, this guy really knows, or this lady really knows what they're doing. And you have a much more complicated negotiation process. Or the person knows what they're doing, and they're not going to sign it. So what does the company do? Well, they go and they find, again, we'll call it the lowest hanging fruit, but no, they go and they find the worst agreement. They find what a lawyer sent in who really didn't do anything significant. They just sent something back to the company, say, I would like to see this change or that change. So then you as a company go, let's go out to the people and say, well, here's what this other attorney did. Here's what another attorney did. Well, yeah, they might have done an absolutely terrible job for their client. Look, maybe they did a great job, but maybe they didn't. And if they did a great job, and if it was something that was really powerful or beneficial to the landowner, would the company come out and start handing that out to everybody? Or would they say, you know what, it's no big deal. Not really any significant changes. Doesn't really impact us at all. We don't care. Let's go out and say, hey, landowner, no need to call in a lawyer who is going to work for you. No need to think too much about this because one of your neighbors or somebody else in the area, well, they already did that. And they hired an attorney. And here's what that attorney agreed to. Well, listen, I don't care if it's a multi-unit well consent. I don't care if it's a lease. I don't care if it's a pipeline. And boy, I've seen this happen in pipelines a lot. There are a lot of people that don't know what they're doing. And if you're following suit, it's the old thing. Everyone's jumping off the bridge. You get the lemmings. If you're following suit, well, what are you doing? You're making the same mistake. So when a company landman says, oh, here's what this other lawyer did, remember, we don't know if that lawyer had the same leverage position, if they had experience in doing this, how long they fought, what was involved. There are so many unknowns. You cannot just simply piggyback off of some unknown lawyer for some document that the company is giving you and trying to say, hey, follow what these other guys did. Think about that. Well, I got sidetracked there because it's something that happened this week, and I've seen it before along these paths. I don't want to go too far down here, but it's the same type of thing. If the landman comes and says, yeah, this guy signed for $10 or $15 a foot for a pipeline, $15 a foot, my opinion, way too low. $15 a foot, signs. Oh, and here's some addendum terms, and this is what this attorney did. I've seen, unfortunately, attorneys, in my opinion, not do what I would do. I'll put it that way. Certainly not do what I would do. So then they come to you and they say, oh, this farmer had 500 acres and he's well known in the community and he had a lawyer and here's what he agreed to. Again, I don't care. I just had somebody who agreed and we're going to finalize this, and it's going to be I don't want to give too much, but we'll just say well into the high hundreds of dollars a foot. Had they simply signed, their payment would have been not very much at all. Not very much at all. So you owe it to yourself, you owe it to your family, you owe it to the property, you owe it to the future generations. You have to make sure before you sign that you're maximizing whatever it is that's being presented to you. And also, you may not even want to sign. You need to understand your rights. So I'm going to talk when I get back. I'm going to get back on track, but it's so important. It kills me because I know we got landmen going out there. We got people, representatives going out and saying things like, oh, here's what the other attorney did. Here's what your neighbor did. You might as well do the same thing. This is what we're paying. I don't care about that. I care about you. I care about your situation, not your neighbor's situation. Because maybe your neighbor did really bad and didn't do a good job. And maybe their attorney didn't do a good job. Or maybe they didn't have the leverage that you have. And so, of course, the company's going to present that to you. Of course they are. Think about that. All right, we're up against it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. If you have a multi-unit well consent, pipeline agreement, any agreement, but we'll focus on those just for the purpose of the show, but any agreement, give us a call, learn about reviews and consultations. Do not simply sign documents. Give us a call, see if we're right for you. If you don't call us, call someone who knows what they're doing, who's going to work for you. We do these reviews and consultations. They usually, for the multi-unit wells, usually about an hour total, usually. And gas leases, pipeline agreements, when we do reviews and consultations, they're usually 1 to 2 hours, usually. So give us a call, 570-307-0702. We want to hear from you. We want to help you. We want to give you the information to allow you to make the right decision. That's our goal, and that's what we need to do, and that's the information you need to have. 570-307-0702. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And remember, join us every Sunday, 8 to 9 a.m. right here on this station for the information that you need from the landowner's side regarding natural gas development. Tune in every Sunday. And if you can't tune in every Sunday, go to the websites, pagasleaseattorney.com, pipelineattorney.com. Use the websites as a resource, whether you're looking for representation or information. Use the websites as a resource. We have all the shows, recent shows, up and posted. We have this show up on Monday morning. Check it out. Anytime during the week, any of the other shows, go check out the radio show at pagasleaseattorney.com, pipelineattorney.com. Okay, I'm going to circle back now, and we're going to talk, again, I was saying a couple issues I want to talk about here today. We have the multi-unit well consent issue, which is facing a lot of people in Susquehanna County and some in Bradford. And we have the top lease, and you have pipelines as well, but these leases that are being presented to people in Tioga County when they actually already have an active lease. And so the kind of the theme then of what I'm getting at is, look, you sign a lease at some point in time. That's document one. I've talked for years, since 2010, doing this radio show about that lease being the blueprint for the future. So we want to make sure that we have the strongest blueprint, the strongest foundation as we move forward. So after you sign a lease, many people are presented with additional documents in the future. Those documents may be an amendment and modification of your lease. It may be a new top lease, like in Tioga County we see often. It may be a multi-unit well consent form, Susquehanna County, some in Bradford County. It may be a pipeline agreement. It may be a well pad agreement. It may be a release. Any other type of document. There's many of them. So you sign a lease, but that may not be the end of it. So one of the things that we're seeing in Susquehanna County a lot at the present time are these consents that are being requested to the landowner to sign a consent form to allow what's called a multi-unit well or wells. You need to understand those. And you don't need to understand them solely from what the company wants to tell you. You need to understand them from your own perspective. You need to understand what this may mean for you. You need to understand this and then make your decision. I'm not telling anyone that you shouldn't sign something. What I say is you need to understand it. Then you need to understand, can I change it to make it better? To make it to the point where I can sign it, or it is appropriate, or I feel it is in my best interest to sign the document. But, I say all the time, stop signing bad agreements. We need to look at it, look at your specific situation, and again, not even your neighbors, your situation. How does it impact you? What does this mean to you and your property? So that's just an example, multi-unit well consents in Susquehanna and that area. And what we're seeing is Cabot Oil and Gas presenting these documents to people. That's one thing we're talking about. Now, let's talk about Tioga County area. There, we have many, many landowners who have active, existing oil and gas leases. And the company now comes to them, SWEPI LP, comes to them and says, hey, we want you to sign a new lease. And you say, well, my lease doesn't expire yet. We want you to sign a new lease. Well, there's a reason for that. There's a reason. There's more than one. But in my opinion, there's one really, really big reason. And I'm going to tell you, I talk to my clients who we do these reviews and consultations, and I've done a lot of them. And I say, one thing that interests me, can you tell me, did you ask the landman why you're being presented with this new lease when you already have an existing lease? Why are you giving me this new lease? Did you ask that question? And I'm going to tell you guys out there, if you're in this situation, ask that question. And write down the answer if you can, or take some notes of the answer. But ask that question and see what they say. And I'm going to tell you, in my opinion, I haven't heard what a landman or a representative respond to the landowner, at least what they've told me, I haven't heard them explain the reason why they're doing it in the same fashion as to why I think they're doing it. And I'll say that I think a very, very large reason, and I think the biggest reason, is that under the new lease form, the company has found a way, contractually found a way, not, it's in the document, to end up paying you less royalty payments under the new lease than what you would have received under the old lease. My opinion goes on further to say that this new lease form that you're presented with, this bonus $1,000, $1,500, $2,000 per acre, they're going to give you that. But my opinion, boy, they're going to take in the back end. They are going to take in the back end. And those are the things that we're going to talk about. And that's where you need to get detailed, specific information. You need to understand your rights. You need to look at, this isn't like 2008 and people were just printing off, lawyers, every lawyer in the state was an oil and gas lawyer now, and they're printing off addendums and they're copying and pasting addendums and saying, here you go, this is what you need. No, we need to look at your situation. We need to look at permitting, drilling permits. What is drilled? What type of well was drilled? When was the spud date of the well? Is it producing? How are units formed? Are units formed at this time? Is there a well drilled under your property? Potential game changer. I'm very confident there are people signing amendments, modifications, new gas leases, multi-unit well documents that are very bad for them in their situation. That's why we need to make sure, and that's why I started to do way more of these reviews and consultations. So you can say, well, I don't know how much I want to be involved in this, how much I want to spend, how much I want to get involved. I don't want a big fight here. We're not talking about fights. We're talking about giving you the information that you need to know to decide, is this a good thing for me or not? Is this what I want to do? That's what we want to do. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me right here every Sunday, 8 to 9 a.m. for All Things Marcellus. Give me a call. You have any of these agreements, you want to learn more about reviews, consultations, or much more, anything oil and gas related, 570-307-0702. Also go to the website for the Clark Law Firm, pagasleaseattorney.com, and the sister site, pipelineattorney.com. Education, information, that's the key. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Right here, join me every Saturday, 9 to 10 a.m. on KC 101, 9 to 10 a.m. And Tioga County, if you have a top lease offer, I really would like to hear from you, hoping we could maybe do a review and consultation, because I truly believe that is going to be very beneficial and you'll understand so much more. We'll give you the information that you need to know, not the information that only the information that the company wants you to know. No, we're going to give you what you need to know. And then you make the right decision. Give us a call, 570-307-0702. Learn about reviews and consultations and see if it's right for you. 570-307-0702. Okay, so I went a little long in the first segment there, so we're going to cut this one a little bit shorter, and there's some things I really want to get to and not be interrupted with any breaks, and especially we're going to talk about, listen, do not change the channel. I hate to say that, but don't, because I'm going to talk about Tioga County and some of the things going on there. So if you're in Tioga County, you want to hear this. If you're anywhere else, you want to hear this and say probably, whew, I'm glad I'm not there. If you're in Susquehanna County, you're going to want to hear this because you're going to say, well, okay, I need to know about these multi-unit well consents, and I want to at least get some information so I can realize, do I need to talk to someone else, or do I just rely on what the company is telling me? So we're going to talk about those more in the next two segments, but I want to just say again, so the idea of the show is you sign a lease. This is just today's show. The idea of the show is to get you information, to get you thinking, to, not specific advice for anybody, but to get you thinking about things that you should be thinking about, and to encourage you to go get specific advice. Whether you come to us, the Clark Law Firm, or you go anywhere else, get specific advice for you. As we say all the time, that's the key. So for today's show, we're really looking at, once you sign a gas lease, there may be other documents that are presented to you to sign in the future. Amendments and modifications. We're talking about top leases and second leases that are being presented to people in Tioga County. We're focusing on that some today. We're talking about multi-unit well consent forms that are being presented to people in primarily Susquehanna County, but also Bradford County as well. But there are others. The same types of ideas apply to pipelines. If you are putting pen to paper and you've not talked to an attorney who is experienced in oil and gas and gives you advice, if you don't do at least a review and consultation, whether it would be me or someone else, I believe you are making a mistake. You can go online, you can look at the Penn State websites, you can look anywhere of any reputable place. It'll tell you, hey, get some assistance. Get an attorney who's experienced to help you. And it's really true. It's really true. And I know it sounds self-serving, and it is what it is. I am an attorney who does oil and gas related matters. Whether you call me or call someone else, call. Get someone who's going to give you the information that you need and not rely on the company landman because they work for the company. They do not. They do not work for you. I'll be right back after this break. Remember, join me every Sunday, 8 to 9 a.m., right here in this station. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me every single Sunday, 8 to 9 a.m., right here in this station for All Things Marcellus. And the information that you need regarding natural gas development in Pennsylvania and Susquehanna County landowners, if you have a consent to multi-unit wells, give us a call, Clark Law Firm, 570-307-0702. See if we can help you, see if a review and consultation is right for you. Give us a call. Check it out, 570-307-0702. If you don't call me, call someone, but just don't sign agreements that are presented to you. Get some assistance. Okay, we're going to talk now, all right? We're going to talk the top lease when you have an existing lease and the company presents you with a new lease, and we're going to kind of talk more specifically about Tioga County, what we're seeing, but a lot of the principles apply elsewhere as well. But the lesson is also get assistance and talk to somebody who's working for you, who's going to tell you the information that you need, not just the information that the company wants you to have. So, okay, Tioga County, SWEPI LP, you have an existing gas lease. The owner or lessee of the gas lease is a company called SWEPI LP. They're offering you a new gas lease now. And you say, well, wait a second. I have a gas lease. Why are you offering me a new one? Why are you offering a new one at, say, $2,000 an acre? Why are you doing that? A per acre bonus. Well, again, why? I'll tell you. There's probably a few different reasons. In my opinion, I'll say it again, in my opinion, the reason that this offer is occurring is because the offer is going to significantly, drastically, enormously change, I believe, how your royalties will be calculated. Meaning, your royalties will be calculated one way under your existing lease, and they'll be calculated a different way under your new top lease if you sign it and you move forward. Why are they offering you a new lease? Because it's better for them? Think about that. Are they offering you a new lease because they just want to give you more money? Because it's going to be better for them. They want to be fair to you. They haven't developed yet, so they just think this is a fair thing to do. You think that's the case? Do you really ever think that is the case? Think about those questions. Think about what is the real reason this is occurring. Again, my opinion, I hold it firmly, is this is being done so that the company will pay you a lot less royalties, in my opinion, under the new lease than they would under your existing lease. And in my opinion, that's true in most cases, in almost all, whether you have a 12.5, well, let me say it this way. Again, none of this is specific advice. This is general information. But if I had a lease at 12.5% and I had a new lease offer at 15%, the way these royalties are calculated, and this is people get too tied up on the numbers, there are many leases that I'd rather have 12.5% and have my royalties calculated without deductions, without the ability of the company to use index pricing and affiliated sales, sell it to themselves, set an index price, then take deductions and pay you a whole lot less money. Well, I would rather have, in some scenarios, I'd rather have 12.5% than 25% with full deductions and affiliated sales. Again, not specific advice. We need to look at your situation. We need to talk about it in detail. But understand, this is not being done because all of a sudden the company thinks, hey, we want to be great with these landowners and give them free money, so we'll give them a new lease. Well, then what if you say, well, you know what, thank you, but no thank you, I'm going to stick with my old lease. And the company says to themselves, well, hey, look, we're trying to give these guys free money. And they say, no, well, all right, landowner, it was nice speaking with you. We'll move on and we won't give you the free money. But then they come back because, man, they are heck bent on giving you free money. They are heck bent on giving you free money because that's what they're in the business of doing. Or maybe there's a benefit for them, and maybe it's a significant benefit for them. Maybe in the long run, it'll be hundreds of thousands of dollars benefit to them, detriment to you. Maybe. We got to look at your situation, your acreage, your original lease, the new lease language. But I'm telling you, you need to look at those things. You need to look at those things with someone working for you. And that's why I say these reviews and consultations, I know I'm a broken record, but man, 1 to 2 hours a time, we talk. I explain it to you. I do them by phone all the time, but you're more than welcome to come in. I love every time I see them on the calendar. When I'm doing these, I am excited about it because I get to tell people things that they need to know to make the right decision. And I know that I'm going to tell them things that the company is not telling them. And I'm going to give you, the landowner, the tools to decide what's right for you. And we're going to look at this specific to you and your situation, because they are not always the same. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, right here every week at this time on this station. So we need to get you that advice. So again, remember, this isn't specific advice. I am not saying to you, hey, listen to the radio and don't sign. Listen to the radio show and sign. No. The radio show is to get you thinking, to get you this information, what you should be thinking about, to encourage you to either call us or to call someone else, but to call and get somebody who's working for you. That's the idea. But when we want to ask these questions, why am I getting this? And you need to get these answers. And I can't give you all the specific. We're talking general items here. I can't get into your specific case on the radio show because I don't know your acreage, your existing lease. I don't know the drilling activity in your area, the unitization activity in your area. That's what we'll look at. That's what I'll look at and be prepared and have these discussions with you on an individual basis. That's what we do. I can tell you, though, generally speaking, that I'm very aware that most of these leases, when people have an existing lease and now they're being presented with a top lease from Shell or SWEPI LP, that most of the time the existing is an existing east lease signed years ago, and that the landowner now, by signing the new agreement, is going to be changing the way royalties are going to be paid. That's what I see as a very common occurrence. I can't tell you that's happening to you, but I can tell you it is very common, and you need to understand that, and you really need to understand that and talk to somebody that's going to give you that information, and then decide, what do you want to do? Real quick, last year, I might have talked about this last week, but last year, client offered $2,500 to sign this lease extension modification and amendment. Didn't do it. Just signed this week over $1 million agreement. $2,500. We did a review and consultation. Said, look, my strongest opinion, you don't want to sign this. 1 year later, signed a lease for over $1 million. Now, what does that tell you? It tells you you need to get information before you go and sign. Because, gosh, there's people out there that may be in that situation and just signed and got $2,500 and were happy, and literally may have missed out on whatever that number may be. $1 million, $500,000, maybe $100,000, maybe $50,000. But whatever it is, it might have been something significant, and you could have had a review and consultation, fully understood your circumstances, and then decide, hey, is this right for me or not? Another thing I want to talk about, SWEPI LP. If you're in Tioga County, listen to this, what I'm about to tell you. SWEPI LP, as of May, Shell SWEPI, as of May 2017, has wells that are placed into what's called regulatory inactive status. Well, how many wells? What does that mean? Well, as of May 2017, SWEPI has 175 wells that have been declared regulatory inactive or given regulatory inactive status. 175 wells, 51 of them horizontal, 124 of them vertical, published by DEP. 175 wells. Now, landowner, you have an existing lease. It expires later this year, next year. We want you to sign a new lease for 7 years. And once you sign this new lease, if it starts, say, in 2018, now it's 7 years, that's 2025, which means that the company may have to drill a well, maybe file a permit by the year 2025. Then, like these 175 wells that are currently in regulatory inactive status as of May of 2017, well, maybe come 2025, that well that's drilled is now placed in regulatory inactive status. And they get a 5-year window on that. On that. Now, it depends on shut-in. There's other things that are relevant. But, so we go 7-year lease. That takes us to 2025. If we say our lease expires next year. So we sign a new lease that allows the company until 2025 to file a permit or maybe drill a well. Then they can put it into regulatory inactive status. Maybe they don't. Maybe they start producing next year. But we can tell you this. Hey, SWEPI, can you explain to me why there are 175 wells as of May 2017 in regulatory inactive status? Go do the research. Look at the other companies. See what they're doing. And why are you offering me a 7-year lease on top of what I have? Why are you doing that? Why are you putting all these wells in regulatory inactive status? Ask this question. If my lease expires in 2018, I signed this 7-year lease. Now you have until 2025 to conduct operations which may or may not include drilling a well. Then you drill a well, then you cap it, you shut it in, you put it in regulatory inactive status for 5 years, let's say. Now we're at 2030. That's 13 years from now and 12 years from next year. It's a long time away. Again, this isn't specific advice. I'm not telling people to sign or not sign. I'm saying that there's information out there that keep listening to the show because we're going to keep giving it to you. But I don't think the company's talking about these things. I don't think they're talking about how your royalties calculation method may significantly change to your detriment should you sign the new lease. However, we have to look at everything, because maybe signing the new lease is what you need to do in your situation that makes the most sense, that's right for you. But man, do we have to talk about it. We have to look at it. We have to talk about it. And if you call us, learn about the reviews and consultations, they are with me and me alone. Telephone, in person, whatever you want. But I personally want you to have this information so you might make the right decision. And I'm going to tell you, that right decision may be, hey, look, I would sign this. Or it may be, look, you can negotiate this and make it a little better and then sign. It makes the most sense in your situation. Or it may be, man, am I glad you called, because, boy, this is really clear. You shouldn't have signed, or you shouldn't sign. Again, I'm not telling you any of those things on the radio show. And I don't mean that, because we have to look at your situation. And the idea is this isn't specific advice. But boy, we have to get you specific advice. Call the office, learn what we do, 570-307-0702. I've talked to so many people in Tioga County, and they've said, thank you so much. This has been such a great help. And look, I get so much satisfaction from that, because that's what we want to do. Get you the information and you make your decision. But get the information, whether you call me, 570-307-0702, or call someone else who knows what they're doing. Call someone. I'll be right back after this break. We're going to talk about the multi-unit well issues, same type of thing. Before you sign, talk to somebody working for you. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me every week at this time on this station. We're short on time. This is a short segment. I went long on the first one, but I didn't want to stop because we were really rolling there. So we're going to talk about the consent to multi-unit wells documents that are being presented to Susquehanna County area landowners. Again, been doing reviews and consultations. Give us a call, 570-307-0702. Find out if we can help you, what this means or may mean to you, and get specific advice. Very, very important, in my opinion, in these documents, that you need to get specific advice. Also, when you're sent something in the mail, my opinion, boy, do not sign it and just return it. They send these out and say, here's the enclosed envelope. Please have this production sharing agreement. Have it notarized. Return it to Cabot in the enclosed envelope within 30 days of receiving this letter. Like, it almost sounds scary. You have no obligation to do that. You have no obligation to do that. You have no obligation to do that. You have to understand that first and foremost. We cannot just have a pattern where you're signing documents that are mailed to you. I talked to somebody who said, oh, yeah, my mother received this, and she thought, well, since she was under lease, she had to just go ahead and sign it, return it. Well, yeah, companies will prey on that mentality. That's not specific to Cabot in this case. It's my general opinion that certainly companies know this. Again, let's take Cabot out of the picture. I don't want to be specific on any company, but in general, companies know that some people are just going to sign whatever they send them. So, of course, they're going to send them documents to say, return this in 30 days. Let's make it as easy as possible. Let's also maybe include some things in here in a cover letter saying how great this is going to be for you. Then, send it out to people. And I will guarantee you that there are people who sign these type of documents that should not sign these documents, that should not, if they want to do what's best for them, sign the documents. But there may also be people who want to do what's best for them, who should sign, or more likely should request and have these documents modified or amended to make it more appropriate for them to sign, not just sign the form. I talk about low-hanging fruit so much. This is All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I talk about this low-hanging fruit. And what I mean, and I don't mean it disrespectfully for any individuals, but it gives an illustration that the lowest of the low-hanging fruit are the people who will just sign anything, and they'll just sign anything that you even mail to them. Not that you send a landman out to their house and they'll sign whatever you put in front of them. No, you just have to mail it. Hey, here, sign this, return it. I have personally seen people lose millions of dollars, because they just signed things they got in the mail. And that's a shame. And that's what we want to prevent against. The companies have enough money. Let's make sure that you're doing the best you can for you. This is your asset. This is your land. These are your oil and gas rights. Maximize them for you, for your children, for your grandchildren. I have 2 children who one is just graduating and he's going off to law school, very proud, and the other one's in college. It's very expensive. You need to, for your children and your grandchildren, maximize these agreements. You owe it to yourself and your family to understand what you're being asked to sign before you sign it. You should never, my strongest opinion, never simply sign documents that are presented to you in the mail. You're going to notarize. I mean, you can't just sign these documents. If you don't call me, call someone. Call someone who's going to work for you and tell you what you need to know. But you can't just sign documents. You can't just sign major contracts for the industrial development of your property for future generations and just sign them because you got it in the mail and it said, oh, here, sign it and return it. You got to stop doing that. You need to get the information. You need to get information. And again, I'd love to hear from you. But if it's not me, get it from somebody working for you. This is what the show is about. Thinking, understanding, asking the questions, and realizing I need to get more information. This document says that in this consent to multi-unit wells, same type of document everyone's getting, the company in its sole discretion may drill, complete, or produce or operate one or more wells that traverse a lease unit and one or more other pools or units, each a multi-unit well. First off, you got to understand what that means. You have to understand that you're giving the company the authority to do something that they may or may not do, and that's really important. You need to also understand that here's the word of all, or the sentence of all sentences. The terms of this consent, which is the document, will control in the event there is a conflict with the terms of the with the terms of the lease and/or any declaration of pooling. Man, do you need to know what that is. You need to understand that, and you need to get the assistance. Whether you call me or call someone else, call. You have to understand that this document, although it's called a consent to multi-unit wells, states in there, buried down, second to the last paragraph on the first page, the terms of this consent will control in the event there is a conflict with the terms of the lease, meaning your gas lease, and or any declaration of pooling. You have to realize the impact of that language. The good news is the evaluation that I'm doing with clients on these issues usually takes about an hour total. So get the information. See if we can do it for you. We need to make sure that we can do it for you. 570-307-0702. But give us a call. See if we can help you. Remember, we have to stop signing bad agreements. We have to stop signing bad agreements. And again, the landman is working for the company, not you, the landowner. Have a great week, everyone. See you next week. 570-307-0702.